Extension of Data Protection Act. It's important for you and for me. But perhaps once you hear about act, you immediately think complex, complicated, not easy to understand, big words. Because the content is far reaching and definitely has implications as a game changer in how we collect, store, and retain your information, among other things, we thought it important to stage this half an hour webinar today entitled Why Your Data Matters, Your Rights as a Utility Consumer under the Data Protection Act. Hello, I am Elizabeth Bennett Marsh, the Public Education Specialist at the Office of the Utilities Regulation in Jamaica, and we are the hosts of today's webinar. The new Data Protection Act came into effect on December 1, 2023. It provides greater safeguards for the handling of personal information of Jamaicans held in physical or electronic form. Entities, particularly those like the OUR, that process personal information on a daily basis, are required to implement measures to ensure the safety, security, and confidentiality of the data they handle, and failure to do so could result in them facing harsh penalties, including hefty fines. But I stop here because I have two of OUR's in-house experts who will be providing you with more information that will be of use to you. I have joining me Leighton Hamilton, OUR's Director of Information Technology and Risk, and Naomi Watkins, one of our legal officers who has been tasked with ensuring that we are complying with the stipulations and requirements under the Data Protection Act. Leighton, Naomi, welcome. Naomi, we're going to start with you, and I hand over to you for your presentation. And we invite persons who are joining us on YouTube or Facebook to post your questions in the chat for Naomi or Leighton or the OUR in general, and we'll have them answered as soon as the presentations are completed.
Thank you, Liz. All right, so as Elizabeth has said, the Data Protection Act, which actually came into full effect on the 1st of December 2023, is one of the hot topics because there are so many entities across the country who now falls under the ambit of this particular piece of legislation. So one of the things that I would like to do is to highlight a few terms under the act itself, because in an ideal world, everything would have the literal meaning that all of us know. But as it is with the law, as much as Liz don't like all of these legalese that is here, we need to ensure that what we have is what is provided for under the act. So first and foremost, I would like to point out that this is about the OUR as what is called a data controller under the act. So the OUR is a public authority, and under the act, we're deemed to be a data controller. We determine the purposes for which personal data is collected. So please remember, in this context, the OUR is a data controller. We are not acting as taking care or assessing compliance with the Data Protection Act. There's another regulator for that, which is the Office of the Information Commissioner. Thanks. All right, so personal data is, in the context of the act, is about a natural individual, not a company, not another entity. And it says living or somebody who has been dead for no more than 30 years. All right, so there is a special category of personal data which the act makes special reference to, which is called sensitive personal data. And we'll prefer for you to look at this definition rather than what you think it is. So here are some examples: genetic data, stuff about your racial or your ethnic origin, your political opinions, membership. And this set of data has been highlighted because under the Act, you're protecting the fundamental rights of humans. And these are actually areas which you're deemed especially sensitive and can be used against persons. So hence the reason for highlighting these. And before we go on, I must say that a part of data protection from the OUR's perspective is that we are asking our stakeholders, persons who provide information to us, whether they have a complaint, they have a query. We're asking you, please do not submit any sensitive data to us, because these type of information, we don't usually utilize them in our investigations. As it relates to other stakeholders, like for license applicants, if there's anything that falls within this category that is required, that is not on the prescribed form that is used, we will write to you and request it. But please don't submit this to us. Help us to help you to protect your information. All right, so data subject, as I say, is who the information is about. So while this webinar, the title speaks about your rights as a consumer, under the Data Protection Act, everybody whose information is processed is a data subject. And all data subjects, whether you're a consumer, you're a customer of the utility provider, you're a licensed applicant, you're an employee, you are a data subject. And one of the standards on the Data Protection Act, which needs to be protected, provides rights. It speaks to the rights of data subjects. So everybody has these rights. Right. And we speak about process, and know that sometimes when you hear process, you think of something that you carry out some operations on. So if you look at to my left, some things here that looks like some gear, but it's not necessarily that you're carrying out some process on the data. Processing under the Act is that once the information comes within your site, once you receive it, anything at all that you do with it, you input it into some database, you create paper files, you destroy it, you make corrections to it. All of that is included in processing. So as you can see that anytime personal information gets into the hands of a data controller, processing is going on. So here we have some examples of what is considered processing. And move on, please. All of these, it goes all the way up to when you actually destroy the information. So back to us at the OUR. The type of personal data that we process, it includes names, email addresses, contact numbers for our stakeholders, which would include you consumers who contact us, whether you have a complaint, whether you're asking for some information regarding the regulated entities. It has persons who just have general interest in what is happening in the utility sectors. We have our license applicants. And of course, we, the OUR employees, a lot of information. Anybody who is an employee ought to know that their employer collects a lot of information on them for various reasons. And speaking of various reasons for collecting personal information, here at the OUR, we collect personal information because we have legal obligations that's prescribed under different laws. The law that governs the operation of the OUR Act. We have sector-specific legislation, the National Water Commission Act, the Electricity Act, the Telecommunications Act. There are provisions in the different licenses that asks certain things of the OUR. We also conduct investigations, whether it's complaints that we receive from consumers. It could also be observations that we have made. Sometimes, Liz is here to tell you that we monitor what happens in the media. So sometimes we pick up things there, and it's in the best interest of regulating the sectors to act on it. We also are tasked with tariff determination, and in that instances, we also may use some personal data process. All right, so the Data Protection Act has provisions that we must adhere to, we must comply with. So we are currently in the process of doing that. So I said the act came into full effect in December. So it's actually in its infancy. These are some of the things that we're required to do. So one of the first things is to register with the Office of the Information Commissioner. But if you have been paying attention, in December, when the act took full effect, the regulator, the Office of the Information Commissioner, advised that there's a grace period of 6 months to register. So up to this morning, when we check, the registration process still has not been opened for data controllers because there are some other, well, essentially the regulations to deal with that part from the Office of the Information Commissioner is not fully in place as yet. But we are putting everything together. So once that portal is open, we have actually created our account already. We'll be ready to go on and register. The Act also asks for us to appoint a data protection officer, who is the officer who is responsible for compliance within the OUR. So we have appointed our data protection officer already. We are in the process of creating different data protection policies and procedures. We have started staff training and sensitization, and that will continue. Next. All right. So there are actually consequences under the Act, and Liz mentioned some just in passing before that. Listen, it's not just a matter of that this is here. We are required to comply with it, and if we don't comply, there are actually stiff penalties in instances in the millions of dollars. It also comes with terms of imprisonment for officers of data controllers if they don't comply. So even if you don't think there's a reason to comply, there are actually incentives to comply because you don't want your entity to face fines, or you are certainly doesn't want to do that. We don't want our personnel to face fines. So being good citizen that we are, we always endeavor to comply, but there's even more reason to do so. And there's also the possibility of being faced with damages, having to pay out damages, because under the Act, if a data subject information is breached and they suffer damage, they're entitled to compensation for whatever damage they suffer. Plus, they're also entitled to compensation for any distress that damage caused upon them. So it's twofold. So maybe if you're used to the US justice system, you will hear about pain and suffering. So it's kind of that type of component. So as Liz mentioned before, we have another officer from the OUR, another expert who will be speaking. Just to mention before we segue to Leighton that there are 8 standards under the Data Protection Act that data controllers need to comply with. And one of them is ensuring that appropriate organizational and technical measures are in place. So my colleague Leighton is better placed to speak to that. And before you go over to Leighton, on here we have our information for our data protection officer. So for persons out there, if you want to get in touch with the OUR about the Data Protection Act, this is the email address. This is the contact number that you would need to call. Thank you.
Thank you very much. Naomi Watkins is one of our legal counsels here at the OUR, and she's been tasked with ensuring that we are complying, and will be fully compliant once everything has been rolled out as stipulated by the Act. And she mentioned the fact that, whilst we are collecting data, we're sensitizing the staff, etc., we're talking about retention periods for your data, etc. Data breach is a very, very serious matter. Even before the Data Protection Act was a thing, the OUR was very, very big on ensuring that your data is very well protected. And so I now segue to Leighton Hamilton, who is our Director for Information Technology and Risk, to talk about the technical side of the compliance under the Data Protection Act. Leighton.
Good morning, all. I've been tasked with trying to talk about cybersecurity risks and the risk management associated with data protection. And all of this has to relate to the rights of the consumer. Now, to talk about this topic, we have to understand the data protection, as Naomi talked about, was that it's not just electronic data, it's also physical data. Now, electronic data and cybersecurity goes hand in hand. So putting the two together, you're probably all thinking that we're going to be speaking about just electronic data. No, we're not. We're speaking about all personal data, whether it is written down or stored electronically. The difference between the two areas are very simple. It is a lot easier to see. You can remove or you can capture more data electronically than physically. If someone had to break into an office, such as the OUR, to get personal data, they have to go to a number of files, physical filing cabinets, have to go through doors, locks, a lot of other things. Whereas with cyber attacks, which is one of the main issues with security, you don't have to be physically located in the environment. You can be miles away, thousands of miles away, in another country, and you can try to get the data. Now, how does a company, an organization, such as the OUR, guard against this? We are trying to match risk against rights. So basically, transparency to the consumer as to what data we're capturing from you is important. Why we're capturing the data and what we're going to do with the data is absolutely important. As the OUR, we make it a point of duty to only capture data that is critical to our functions. We capture data for appeals process. We capture data for complaints, and only as it relates to the person making the complaint. We do not ask the licensees to supply us with personal data. We need statistics for our analysis on our performance reporting, but we do not need to know the individual person's name. So one of the things that we'll be doing moving forward with the Data Protection Act is to ensure more and more with our licensee that we do not receive personal identifiable data. Now, consumers, you have the right to review your data held by any provider you've given it to and make adjustments where necessary. How this is crucial is that it is based on anybody's risk profile. You don't want to be an entity, including the OUR, to have incorrect information. So when we do get a complaint, if a licensee has to change their phone number, change their email address, change the actual physical location, we need to know. That goes for anything else in the marketplace. So access and correctness of information is absolutely important. The risk to you and the risk to the organization is if we have to send out information and it goes to the wrong person at the wrong address with the wrong personal information, that could be detrimental to the reputation of us, the OUR, or any other organization. So the ability to review and adjust is critical to ensure that that risk factor is never a consideration. An organization needs to mitigate against any such things by constantly asking persons to do this update. The next is restriction and removal. Restriction means how the data will be used, and consumers, data subjects, can have the ability to have data removed, but only under very, very strict conditions, because some data is absolutely essential that it is kept. So depending on the procedure, some data can be removed. In the OUR, At the moment, we do not have any kind of strictures like that because we only capture data that is absolutely central to either a complaint or an appeal. We do capture data for employees, but again, that is for the operators of the organization. So there will not be the need for removal, but in the general speaking term, that is absolutely critical. Why? If you have data that is not essential to your operation, personal identified data that is not personal to your operation, and you have it, and for some reason it is removed illicitly, it is lost, you the organization can be held responsible, and it's a risk that you do not want to take on. So as a mitigating action, you need to have that data either removed or you need to make sure that it is restricted so securely that it cannot be retrieved. And restriction goes to, and this goes to our next point, data security. All data should be secure, but personal identified data is critical that it needs to be secure. In days of old, before we had computers, you would put it in a room, in a safe, in a vault, with a combination, and it was metal, and a lot of structure running to stop the data from being removed and used against the explicit wish of the consumer. In this cyber world, the security is now a whole new endeavor. We're talking about firewalls and two-factor authentication. But we at OUR, we implement all the requirements to secure data that we keep. All requirements. We have firewalls, we have security officer in place, we constantly monitor our access to all data. We have logs as to who has access to what data. So security of data is critical. You don't want the risk of this being taken from you because you have inadequate security. Risk to the organization losing personal data, again, it goes to reputation. And it goes to the ability of people want to give you information and confident to give you information because the fear of you losing it should not be on their minds. So all the right mitigating actions should be put in place. We at OUR work very, very aggressively to put all of these constructs in place to secure all of our data. Now, we have an issue of, with security goes the other issue of, and I go backwards to removal. If you don't need the data at some point, you should have it removed. So the last point, data anonymization, big long word. The essence of this is really simple. The laws of Jamaica say that you should keep data for 7 years. But for an organization such as the OUR that has to do analysis over years, decades, granted we've only been in place for 27 years. That is 2 decades. We need data for analytical purposes. Need to know number of customers in 1997 when we started. We may need to know number of customers in 1999, the year 2000, and do some kind of comparisons. We need to keep the data of the statistical data of the individual, but we don't need to know that Leighton Hamilton was a customer in 1997 and where he was a customer, where was he located. So the whole thing of going to your data and sanitize the data is critical. Now, with information systems and electronic systems, you can go through and take out data that you don't require, name, address, and so on. You take it out, so if somebody looks at the data, they will not be seeing that information. Now, if we turn this ball around and say, let us look at the physical document. Now, if you have physical documents with this data, now you have a new problem. How are you going to be able to, sanitize data on a physical document? So, where the OUR, are revisiting some of our forms or our forms to be able to look at how can we separate personal data from data that we may use for analytical purposes in the future. We recommend to any organization out there to look at this as a way of looking at how can we minimize consumer privacy. And one of the ways is to find ways of separating data that we can destroy one but keep the other because you may need it for some purpose in the future for some kind of analysis. So that is how we look at the risk and the consumer rights and try to marry the two. Now, we have to take some strategies in risk management to try to find a way to ensure that the Data Protection Act is enforced and we don't make mistakes and lose data and have to be fined by the Commission and pay 4% of annual revenue or any such fines that may cause us to be embarrassed and cause, again, reputational damage. So we need to look at data mapping. When we look at capturing data, we need to know the reason for collecting the data. We are doing that now in the OUR. We're now going to revisit all our forms and say, do we need this data? Why do we need this data? And where we're going to store it and identify the potential risk. And that is going to appear in our risk register. We're also going to look at the minimization of data. We're going to try to find, do we actually need all this data? The OUR does things when we go out and we do meeting the public and we want to get information from the public. We ask things like for email addresses, phone numbers. We are going to have to be very careful how we ask for this information, but we have to tell the consumer what we're going to use it for. In some cases, we may not collect it in the future. We also have to do a privacy impact. Every time a form is going to be put out there to collect information, we're going to have to ask ourselves, what's the impact on the Data Protection Act? What's the impact on the privacy of the consumer? So as a risk strategy, we're going to have to start revisiting how we do things to ensure that we minimize the amount of data that we do capture, and is it absolutely essential that we capture it. And an ongoing exercise, regular training of staff. We have found sensitization sessions with staff are very good to remind people of what we do, how we do it. We do it in other aspects of the organization. We're going to now turn this on the whole issue of data protection and data breaches and what non-compliance would mean to the organization and for you, the individual. So briefly again, we at OUR are very cognizant of what data privacy means to you, the consumer, and your protection. And we are going to be putting more things in place to ensure that. We're also going to be hopefully a beacon to all licensees that we do regulate, to ensure that they try to follow suit in what we are doing, to ensure that your data as a consumer is always protected. Thank you.
Thank you very much. Leighton Hamilton is our Director of Information Technology and Risk, IT and Risk, and he clearly outlined, some of the risks that he, in his capacity, has to look out for, has to anticipate, and put in place mitigating measures. Naomi and Leighton would have highlighted the sum of it is that it is a game changer, more significantly for organizations who have to comply with the Data Protection Act. It will involve a cultural shift within our organizations, from how we store documents to implementing perhaps more paperwork to implementing retention periods where none existed. What kind of information should we discard after a while? What type of information should we retain for statistical purposes, historical references, as Leighton mentioned? We only have a few minutes left on our webinar. We promised you a half an hour. We have a few questions coming in, and I'm going to shoot the first one to Naomi because Naomi used some terms in her presentation. One of them was the Data Protection Officer. What does that person do, Naomi?
Right. So under the Act, the Data Protection Officer is responsible for ensuring that the data controller, the OUR in this instance, is complying, is adhering to our obligations under the Act. The Data Protection Officer is a function that requires the person in that position to be free from conflicts. So, for instance, there is a whistleblowing component. If the data protection officer identifies non-compliance with the Act and has spoken to the relevant officers within the OUR who can fix the non-compliance and they have failed to do so, the data protection officer has a responsibility to go outside of the OUR and bring the matter to the attention of the Office of the Information Commissioner. So, as I said, ensuring that we are complying with the Act, we are doing what is required.
So the OUR has
That
a
person is not
data
involved in
protection.
the day-to-day functioning of our data protection system per se, doesn't make the policies. Because can you imagine if you're the person who is making the policies
Yeah.
and then you turn around reviewing them, you might not be objective if there are challenges.
So all entities are required to have a data protection officer?
Under the Data Protection Act, no, it's not all of all data controllers who are required. So persons, public authorities have been identified as among the entities that require data protection officers. If you process sensitive personal data, and that's why that section was pulled out, you're required to have a data protection officer. And the Information Commissioner can also identify entities, even if it's not prescribed in the Act, that will require to put a data protection officer in place, maybe based on different assessments,
Right. So apart from a data protection officer, there's also a data controller representative.
All right. So under our Act, the data controller representative is not prescribed for an office for a public authority. Is usually for entities that probably is operating outside of Jamaica, establishments outside of Jamaica, but they're processing information and falls under the Data Protection Act. But in our circumstances, we have identified somebody within the organization to communicate directly with the Office of the Information Commission, doing some of the legwork that but is not a position that's prescribed under the Act that must be in place, unlike the data protection officer.
Okay. And while the OUR has been, we have very stringent data and cybersecurity measures in place, have we put in additional measures in place in light of the rollout of the Data Protection Act? Without giving too much details.
Yeah, that is, yes, we have. Yes, we have. We have done some things to even more show up on it. That was outside of the Data Protection Act. That was normal operating procedure with all the threats that have been going on with ransomware attacks to a number of public entities. We were just kind of upped our game to say we need to make sure we have better security. What we have done though is that we have now started looking at our process of designing systems in-house as to what data we do need and what data we don't need. We have had one licensee who has already put out a solution to us that will make us not have to get information from complainants as to their personal data, because once we get an account number from them, we can query the licensing system and get access to the information without having to ask for that information. We don't have to typically store it now. With an account number, we can reference their system. So we try to reduce how much data we do keep. So we're looking at that now going forward for all our new systems.
Okay. The final one for you, Naomi, before we wrap up. It's all good and well to be putting all these systems in place. A lot of persons who are listening to us now are watching us, entities who are also in the throes of implementing the stipulations under the Act. It's a game changer, as I said before. It's a cultural shift what systems, and you talked about sensitization of staff that has been taking place, but what are some of the other measures that we'll be doing just to ensure compliance with this as we move forward?
Well, we have actually been looking at all of our processes in-house. So we're actually working with an external party who is an expert in the area and assessing our system. So we will have a gap audit to find, where our weaknesses, what we can improve on, recommendations, help us because, its data protection is relatively new to Jamaica. It's relatively new to the world, at least the stage that we are at now. So we have to get external help in assisting, but we are all on board. We'll be looking at all our procedures that are in place so that we can comply with these different things, minimize the amount of personal data that we capture, ensuring that we don't keep it for longer than it is necessary. And our staff, because our staff interacting with this personal data, interacting with the OUR employees' personal data too. So, we have to ensure that the measures are there and we are working and we are continually improving on our systems for that protection that's necessary and ensuring that we strike the right balance between protecting personal data that we get while taking care of our interests, carrying out the functions that we are mandated to carry out.
A good note on which to end. Thank you so much. Naomi Watkins is a legal officer here at the Office of Utilities Regulation in Jamaica. And Leighton Hamilton is our Director of Information Technology and Risk, both representatives today. And I want to thank them for joining us and sharing some insight into how we are getting ready for complying with the Data Protection Act. And we have been getting ready and have gotten ready for implementation of the Act and compliance with it, and measures that we'll continue to take in your best interest because we recognize the role that we have to play as a data controller. We want to also thank project manager, producer Gordon Brown, who was also working behind the scenes, as well as Jody and Lawrence, TTN Media, provided our audiovisual services today. And thank you for logging in, and we can continue to have the dialogue. We invite you to pass this link along to persons who may not have got the chance to log in. Share the link with them on our YouTube platform or OUR Jamaica Hub or rebranded, revamped YouTube platform. I am Elizabeth Bennett Marsh, Public Education Specialist at the Office of Utilities Regulation, saying take care until next time.